All right. Good evening and welcome. Excited to have you all here with us this evening. We're very excited to have someone that's going to provide a tremendous amount of value to you in an area that's very important, and that's estate planning. Obviously, being in the financial industry for over 15 years, I've seen the great need for all around planning when it comes to a family's financial future. And this evening, we have the pleasure of having a special guest speaker for our clients that I know is going to bring tremendous amount of value and I think will be extremely informative for you, regardless of where you are at the spectrum. Some of you might be new, just for the first time learning about estate planning. And some of you might be at a point where you're maybe visiting if certain strategies or things need to be visited as far as revising what you already have in place. So regardless of where you fall within that, I know you're going to get a tremendous amount of value. My name is Cindy Gutierrez, and I am a branch office supervisor with Transamerica Financial Advisors. And I have the privilege and pleasure this evening of introducing Jerry Kane. He comes to us from the law offices of Gerald L. Kane. That's based out of Encino, California, and has actually devoted over 25 years helping families protect their wealth and achieve their goals. He has a book of over 3,000 clients, and he's a certified specialist in estate planning, trust and probate law, and an accredited attorney with the Veterans Administration, and is part of the top 5% of attorneys in California as a super lawyer. He's a managing attorney for all Southern California network of attorneys that are part of the Legal Shield Professional Network. And as a father of a special needs child, he understands and relates to families who need to plan for a lifetime disability and is committed to protecting and preserving assets for their care. He's helped individuals and business owners protect their assets from judgments and can help minimize exposure to things like capital gains or income and estate taxes. He's also helped business owners design succession plans to ensure that the business passes to the next generation intact. He's a devoted to veterans. As a VA accredited attorney, his practice has helped countless veterans obtain veterans benefits that help them pay for the needed care and assistance that they may not have obtained without his help. He has served on many boards, including hospital boards and the board of Southern California National Academy of Elder Law Attorneys. He is an in-demand speaker for bar associations and for the Alzheimer's Association and Parkinson. His book, Unraveling the Secrets of VA Benefits, will help many veterans surviving spouses learn about how to qualify for some of the hidden benefits. And he is going to be a tremendous amount of value to us this evening. And so with that, I have the pleasure of introducing Jerry Kane. Go ahead, Jerry.
Wow. Thank you so much, Cynthia. That's an incredible introduction. Thank you for having us. Even virtually, I look forward to one day to be able to do the same meeting face to face and not having to do it virtually. But, we're still, even though we're virtual, a lot of people are being affected by COVID. I know a lot of people may be sick and are dealing with a lot of issues. But, it's business as usual for us. We've always been a cloud platform, and we continue to be a cloud platform. And my private practice, we've transitioned pretty quickly to be able to have all of our employees work remotely. So we're busier than ever and business as usual. Now is probably a great time, if you're on this call listening, don't have an estate plan in place. If you happen to be an agent or you're a client, welcome. And, since there is a lot of time and, it's one of those things that people procrastinate on for whatever reasons, but now there's time to do it. And whether you choose to do the do-it-yourself option, which we'll talk a bit more about, or to have a customized version of a plan with sitting down with me or one of the Legacy Shield network attorneys, just get it done. So often, when I'm doing a meeting like this and I'm in an actual presentation, I'll ask a question, when should you start doing estate planning? And, I'll get all kinds of answers. Usually I don't get the right answer because most people don't think about it, but as soon as you're 18, once you're 18, you want to start doing estate planning because at 18, you're an adult, right? You're considered a legal adult in the eyes of the law, and you're able to make your own legal and financial and healthcare decisions. So, you want to have your own plan in place, but also, who here has kids who are, well, maybe not now, they're not off to college. I think they're all back home. But at some point, they'll be off to college again. If something happens while your kids are away at school, guess what? The college, the hospital, the doctors, they may not communicate with you. And if that individual has lost capacity, God forbid they can't speak for themselves, you're not going to necessarily be able to participate in decision making, and the hospital may not provide you any information because of what we call medical privacy issues. So you want to make sure that you do put a plan in place the moment you turn 18, regardless of your situation. A lot of people think, well, I don't have a tremendous amount of wealth, so I don't need to do planning. No, that's not true. You do have to do planning regardless of your situation. At a minimum, have a basic plan where you're going to put in place a durable financial power of attorney, which allows somebody to contract on your behalf, a healthcare power of attorney, which in California we call an advanced healthcare directive, which allows somebody to make medical decisions for you and allows somebody to, and allows you to be able to convey what kind of heroic measures you would want, whether you'd want to remain on life support indefinitely or, whether you'd want, certain types of measures to be put in place. So, it's still hard to believe, but would you believe that 69% of Americans die without a will still? Again, maybe you don't think you need a plan, but you do need a plan. And, I think unfortunately, it sometimes takes something. It takes, a lot of times I get busier when people happen to be jumping on an airplane. They think something's going to happen. Or, something happens in their life. And, you may be really young. I see some of you on the call are probably, very young. And you probably think, well, I don't need a plan. Well, I thought the same thing. I was 37 years old, and I'll never forget this situation. I was sitting at a Laker game with my first wife, and she said, there's a lump in my throat. And I said, what's going on? And she said, I don't know. It's really painful. So we went to the doctor, and it turned out to be terminal thyroid cancer. I became her caregiver overnight, had to start taking care of her, having to drive her to appointments. I had my own private practice at the same practice that I have now. But, when you're trying to take care of somebody, you're also trying to run your own self-employed type of business, how difficult that can be. So, it really suffered during that time, trying to take care of her and trying to run a business. It nearly bankrupted me. And then she passed away on her 40th birthday, left me with two young girls. One of them, as Cynthia already mentioned, or maybe she didn't mention, has special needs. So, I do a lot of planning for individuals who have disabilities, who have special needs, because that's something that's really near and dear to my heart. And I can relate to what the parents have gone through or will go through, having been there myself. And, by the time I got around to asking her to put together a plan, because we didn't have a plan at that time, all she could do was scribble something out on a piece of paper and do a quick will. I don't know if it would have held up or not. Maybe it would have, maybe it wouldn't have, but thank goodness I didn't need it at that time because, our assets were situated in a way that it wasn't going to cause a court issue, which I'm going to talk about in just a few minutes, what happens with probate. So the time to do planning is now. If you lose capacity or you get too sick or you can't do it, you can't do the planning, and it's too late. So if you don't have legal capacity, you can't plan. And, a lot of people think that, I can do planning at any time. But that's not true. If you lose capacity, you can't plan. So first of all, I'm going to tell you a little bit about what is Legacy Shield. What is the slide maker? All right. So what's Legacy Shield? Basically, it's a digital portal that's going to ensure that all your important information and stories don't get lost, that you can pass on all of your important stories, who you are and what's important to you, your stories, insights, and experiences, and provide security for your entire family, and make sure that your family's life is easier in the event that an event happens, if you lose capacity or if you pass away. In a nutshell, it's a platform that allows you to get the right information to the right people at the right time. Now, you get to name, who gets to receive the information upon the happening of a life event. So if you lose capacity or when you pass away, you get to name the recipients of who's going to receive the information. And it doesn't have to be all or nothing. You can have certain people get certain information. You can have certain things happen if you lose capacity. You can have certain things happen if you pass on. We call those people in Legacy Shield your recipients. Also, you get to name what we call notifiers. And those are people who are going to notify Legacy Shield that a life event has happened. And then, we don't want to just take anybody's word for it that it's actually happened. We have a system in place to ensure that, there's integrity in the system. We call those people authenticators. So the authenticators authenticate that the life event actually happened. So with this whole system of checks and balances, you really know that the right information is going to get to the right people at the right time. So, it's not necessarily just about the money, but it's the reasons behind the money. And that's one of the reasons why the Legacy Shield platform was designed, to hold all of your important information. It's set up in 4 separate sections. It has your important documents, where you can store everything from your Social Security cards to important information, your driver's licenses, your estate plan. Of course, once you get it done, you're going to put your estate plan there, your IRAs, your 401ks. Everything is going to go onto the digital vault. You also have a place for digital assets. These days, probably people have hundreds and hundreds of digital assets. I have to have an app just to track all of my passwords. I've got a password for every single thing that I do, and, there's hundreds of passwords. Imagine if something happens to you. Nobody's going to be able to get access to that information if they don't have the passwords. And a lot of times, everything's digital these days. So, the information is hard to get with the banks or other companies because it's all stored digitally. And if you don't have that key, you don't have the password, you can't get to it. So this is all your email accounts, your frequent flyer mileage, your Facebook accounts, your LinkedIn, your Instagram, your social networking sites, your online trading accounts. You name it, you have hundreds and hundreds of digital assets that need to be placed in a secure way so somebody has access to it and so somebody actually knows about these things. Also, you have a My Wishes section. And this is where you get to tell your story. So in My Wishes section, this is where you get to put down, what kind of burial arrangements you want, services, who you want invited to your funeral, or maybe who you don't want invited to your funeral. You also have My Life Stories, and this is actually where you get to tell, the stories. So there's a template online that gets you started on creating stories that you can pass along from generation to generation. So this is something that can be shared indefinitely with your children and your grandchildren, and possibly, even your great-grandchildren. So let me just illustrate why this is so important. Because one of the attorneys we work with at Legacy Shield, his grandfather, he was from Vietnam, and his grandfather saved up his entire lifetime to be able to send his family to the U.S. In his 80s, he got cancer himself. So instead of actually receiving treatment, what did he do? He gave it to his kids and his grandkids to get an education. So now he's graduated, the grandchild, and he tells the story of his grandfather's legacy, how he was able to send us to America instead of taking care of himself. That's an amazing story. So again, it's not just about the money, but it's the reasons behind the money that this is so important. And the whole portal has unlimited lifetime storage. So when you combine this portal with an estate plan, it becomes a really powerful legacy tool, which is something we often overlook, the experience of leaving all this information and data and family sentimental stuff. So, if you do want to get involved with with the legacy planning aspects of this, you can work with one of our attorneys, and it costs a bit more when you go through a customized plan, which we'll talk a bit more later on, or you can do it yourself and do it on the Legacy Shield platform. So let's talk about what is an estate plan. Well, an estate plan basically is a plan to make sure that everything you own and everything you control gets to the right people at the right time. And this happens when you pass away, and also it happens if you lose capacity. You want to make sure that the right people are going to be in charge. And every estate plan consists of three aspects: a life plan, a transfer plan, and a family plan. So let's first talk about what is a life plan. Well, people are living longer and longer. Sometimes not, in the best of health, but because of modern medicine and modern science, people are living a lot longer than they did before. Unlike your parents or maybe your grandparents who, they retired in their, at 65, they got a nice Rolex watch, they jumped in a Winnebago and they caravanned around the countryside and then gracefully passed away in their sleep. That doesn't happen a lot anymore. If we're fortunate enough, we would just die gracefully in our sleep. But unfortunately, we're living longer, often with, things that are debilitating, like Parkinson's and Alzheimer's and other types of things. So a lot of times when we talk about estate planning, people think it's just what happens when I pass away. But I'll tell you, planning for what happens if you don't pass away is even more important. And as an elder law attorney, I've seen so many situations where people just were caught off guard that they didn't have a life plan in place. They didn't contemplate what would happen if they didn't pass away. They may have taken care of that, but they didn't take care of the life plan side. So I'll give you an example. We had a client who was actually taking care of his wife. His wife had advanced Alzheimer's, and he didn't have a whole lot of his own assets, but his wife had assets. His wife had a 401k. And so he was using his 401k, pulling money out of it at Fidelity. And somehow, I don't know how, Fidelity found out about it. So guess what Fidelity did? They froze the account. He could not access this account anymore. So he's like, well, how am I supposed to pay for her care at, costing him $20,000 to $25,000 a month for round-the-clock caregivers at home? He wanted to make sure she was well taken care of and that she got the best care possible, and so it was costing a lot of money. And he didn't have that money. So he said, well, how am I going to take care of her? So he came to us, and we said, well, have you done any planning? And he said, no, we don't even have a will. We don't have a trust. We don't have a power of attorney. We don't have a healthcare directive. And I said, well, this is a very unfortunate situation, but we're going to have to go to court. We're going to have to go to court and get what's called a conservatorship. We like to call this living probate. We'll talk about death probate in a minute, but living probate also is very expensive, costing tens of thousands of dollars to start a living probate or a conservatorship. And also there's ongoing accountings to the court. So we started this. We named him the person in charge. We call that person the conservator. And then guess what? He passed away. So now we had to go find a professional conservator to jump in because we didn't have anybody else in the family that was willing or able to do it. So this family member jumped in, and not the family member, the professional trustee jumped in, and he was managing the estate, and we were going to try to have the court create an estate plan for her, but guess what? Then she passed away. So without a plan, now all of her assets are tied up in the court and going through a very expensive court process, what we call probate. And again, I promise I'm going to explain what probate is in a few minutes. But it's a very expensive and time-consuming process in order to transfer her assets to the rightful people. So a good plan is going to contemplate planning for life as well as planning for death. And at a minimum, you're going to want to have an advanced healthcare directive, a financial power of attorney, and not every power of attorney you do is going to always be the same, because there are the typical powers of attorney that you can do with a basic plan, but you may want a more customized plan that allows you to have a power of attorney that allows you to, if you need to rely upon government benefits, be able to access those government benefits. So, if you don't have what we call a powerful elder law power of attorney, which allows you to do this, then you may, again, be left with very little flexibility, with very little choice, possibly the choice of having to go into a skilled nursing facility. Because, again, many Americans are living longer. And if you're going to have to rely upon government benefits, you want to make sure that you have the right planning in place to be able to do it. If you're not fortunate enough to be able to qualify for long-term care, or you didn't have the wherewithal to get long-term care insurance while you were able to do it, then chances are you're going to have to rely upon Medi-Cal in California to provide for long-term care. And if you do that, your choice is somewhat limited. So I tell everybody, get long-term care insurance if you can get it, because with Medi-Cal, you're limited to, in most cases, a skilled nursing facility, which costs, normally if you don't have Medi-Cal, it costs $10,000 to $12,000 a month. With Medi-Cal paying for it, Medi-Cal takes care of it, but, skilled nursing facilities aren't the nicest of places. They're not like the assisted living facilities that have, bingo 3 times a day, five meals, lots of activities. They're more like a cruise ship on wheels, whereas a skilled nursing facility isn't. It's more like a hospital environment with linoleum floors. And, I know there's a couple of nurses on here, so they know what I'm talking about. And so they're not always the nicest. And on top of that, what happens is if you do rely upon Medi-Cal, a lot of times what happens if you're married is one spouse is going to burn through all the assets, wiping out millions and millions of dollars. And what does that do? It leaves the surviving spouse impoverished with no assets themselves. And so even if the first spouse is able to pay for their own care, it leaves the surviving spouse with no real options. And again, they have to rely upon government benefits, and they have to rely upon Medi-Cal. So also, a life care plan can include asset protection planning. So this is ensuring that your assets are not exposed to risk in the event that something happens. So for example, you may want to consider creating a legacy for your children and grandchildren. There's a way to design a plan in a way that'll protect your children and grandchildren for multiple generations. We call this legacy planning or a dynasty trust, and those assets then can be protected against failed marriages, against bankruptcies, and against potential creditors. Or if you have a business and you're concerned about, the business having liability, you can structure the business in a way that provides asset protection. So a lot of times the structure of the business provides the asset protection. And, we can do a whole separate presentation on business planning and asset protection for businesses, as well as certain things that you need to think about, like transitioning the business to the next generation, which very few businesses make it to the second and third generation, again, because you didn't plan and the business didn't have a succession plan. So it's important to think about all these things and have a proper asset protection plan in place as well. All right, that's just a little joke there. So do planning while you can, because if you don't recognize your life, chances are you've lost capacity and you can't plan anymore. All right, so the second part of a good plan is a transition plan. And this is basically the transition of your assets, a smooth transition to the next generation or to whoever you're going to leave the assets to. So again, remember that with proper planning, you can preserve the assets when you need them. So you don't have to spend down the assets on your own care, which is a lot of times what happens without proper planning. You end up spending all your assets on your own care because you didn't pre-plan to address those issues. Now, a transition plan also is a plan to avoid probate. Now, probate is a very long and costly process that most families want to avoid it, and it's very easy to avoid a probate in California because all you have to do to avoid probate is have a trust. So what is probate? Probate is basically the legal process that transfers your assets to your heirs. Now, probate, is very time consuming. It can take, anywhere from 12 to 18 months on average for the average probate process to complete. And during this process and during this time, the assets are tied up. You may have difficulty managing business assets. You may have difficulty getting access to assets. And so this is the probate process. It's a very time-consuming process when the assets are tied up in probate. And oftentimes, you appoint somebody in charge, and that person in charge is called the executor or the administrator, and they're often left having to explain why is this process taking so long to all the disgruntled heirs. On top of that, it's a very expensive process, because you have to, first of all, you have to pay filing fees. You have to pay bond premiums. You have to pay for an appraisal of all the assets of the estate. There's so many different costs involved with a probate. I like to think of it as a lawsuit that you file against yourself for the benefit of your creditors with your own money. We estimate that probate costs about 5% of the assets of your estate. And again, it can be so easily avoided by having a fully funded trust. Now, you might be considering having a will instead of having a trust. In some situations, you may be able to have a basic, simple plan where you have a will. Typically, these are situations where, you don't have a significant amount of assets. Maybe you're renting. You don't own real estate. Again, you probably don't have, minor kids. You have, simple situation. You have adult beneficiaries. You have assets that are jointly titled, possibly. You might be able to get away with a will. A will is, it's a good first step to planning because a will at least allows you to name who's going to be in charge. So if you don't name who's going to be in charge, then a judge is going to decide who's in charge. So you get to name who's going to be in charge. And in a will, you can also decide who gets what, possibly how they get it and when they receive it. For example, if you have minor kids, you may say, I don't want them to get it till they're 18. And it also allows you to name guardians for your minor kids. But there's a lot of problems with will. First of all, a will doesn't control all your assets. So if you have assets that are not part of the court process, assets that pass by beneficiary, assets that are jointly held, that pass by contract, those assets are not going to be part of the court process, so they don't control. So if your will says, I want my children to get all my assets, but I don't want them to get it at 18, but I want them to get it when they're 25 or 30 or 35, that can't happen with a will. Because, in that situation, if you have assets that have named beneficiaries, they're going to bypass the will. And they won't be, they won't happen through the probate court process. However, if you do have beneficiaries who are minors, even if you try to avoid the process of probate altogether by naming beneficiaries, for example, so if you name your minor child as a beneficiary on an account or on an IRA or a 401k, guess what? Those assets are going to be brought back into the probate process. So they'll be brought back into the probate process. It'll create a probate because a minor can't manage assets. So a process will have to be created for those assets to be managed, and they're going to get every single dollar of those assets when they turn to be an adult at 18. And again, you probably don't want that to happen because an 18-year-old, even if they were to, get a small estate, let's say they got a couple $100,000, chances are they're not going to, they're not going to graduate college. They're probably not going to be, They're probably going to buy a nice car. They're not going to really know how to manage those assets at 18. They may decide to get into trouble and do things they shouldn't be doing. So a lot of times you don't want 18-year-olds to get assets all in one lump sum completely at 18. So with all these problems of probate, why doesn't everybody just avoid probate? It's easy to do. And as I already mentioned, probate is a voluntary process. Nobody has to go through probate, especially in California. Because if you have a trust and you properly put your assets into that trust, you're not going to go through probate. So it's not enough just to set up a trust. A lot of times people think, hey, I can just set up a trust, I'm done. You have to make sure that trust is properly funded and that each and every asset is titled in the name of the trust. Because if you don't properly transfer all of your assets, you don't properly transfer all your bank accounts, all of your life insurance policies, all of your real estate into the trust, guess what? You have a worthless piece of paper. And there's a good likelihood it's going to go through probate anyway in that situation. So it's not enough just to set up a trust. You have to fully fund it. And again, this leads me to another story of mine. I actually had a client who, he went to an attorney, a reputable attorney, got a nice, pretty binder that said, congratulations on completing your trust. Now go transfer your assets into the trust. After mom and dad passed away, they brought me the trust. We took a look at it, and then we found out that they never transferred their $1 million stock portfolio into the trust. So I had to tell them, unfortunately, because they never transferred the stock portfolio into the trust, that they're going to have to go through probate anyways. And they weren't very happy about that situation. So again, it's important that a trust, when you set it up, it's done correctly, and that all the assets are properly titled in the trust. And we help walk you through that process. And in some situations, you want to make sure that you're minimizing estate taxes. Now, right now, we are at a situation where most people aren't affected by estate taxes because, there's a $15.5 million exemption from estate taxes. But don't think that you may never be affected by estate taxes, because your estate is everything you own and everything you control. So when you sit down and you add up all of your assets, and it includes life insurance policies, by the way. So if you're the owner of a life insurance policy, that's part of your estate. So potentially you could be creating a large estate and not even know it. And this entire law disappears in 2026, and we go back to the prior law, which was a lot lower. Congress is probably going to do something between now and then, but who knows? Congress might need a lot of money now that they've spent $5 trillion on bailing out the economy with COVID. So they may decide to lower the estate taxes, lower the exemption so that people pay more estate taxes. So don't think that you're never going to be affected by estate taxes, because, estate taxation is something that's always in flux. The estate tax law has actually been put in place 3 or 4 times since 1900 and repealed several times, and the exemption changes all the time. And then lastly, in every good estate plan, I love this, Sam, I've been here for 7 years, and the lawyers still have my will in probate. So, I said probates can take 12 to 16 months. I've had probates that take years. I had one probate just recently. I was getting ready to close it after about a year and a half, 2 years. And all of a sudden, the long-lost son who emigrated from Iran to Canada shows up as the rightful heir. We never knew this son existed. It's a very long story. I won't go into it. But, then it was dragged out for another 2 years in litigation. And the son ended up getting just about everything in the estate. And then lastly is a family plan. And this is also part of a good estate plan, is having a family plan. And a family plan basically is something that allows you to customize a plan to your particular situation. So you can all see, it says here, some of the things that most people commonly fight over after death are tangible personal property. Does anybody know what happened when Robin Williams passed away? what they were actually fighting over? They were fighting over this for a long time. And I know you can't answer, but I would love for you, maybe put it in the chat, take some guesses as to what you think they were fighting over in Robin Williams' estate when he passed away. Anybody want to take a guess? Nobody? All right, well, so I'll tell you. In Robin Williams' estate, they were actually fighting over the Mork and Mindy suspenders. Who was going to get those suspenders? So part of your planning has to ensure that sentimental items, personal property items, are addressed. I'm a big animal lover. We have lots of cats. So, it's important that your plan doesn't treat pets like tangible property. You want to make sure that you know who's going to receive, who's going to care for your pets if something happens to you. So we, in planning, a lot of times you want to specify who do the pets go to. And in some cases, you want to have a more customized plan where you actually create a plan, like I've done for my pets, where you can set aside money for them and somebody to take care of them for the rest of their life. So you know that they'll be taken care of, and they're going to get the same treatment that you would for your pets. Same thing if you have children who have disabilities. Again, you want to make sure that you have a plan in place for those individuals that can take care of them for the rest of their life. It has to be properly funded. It has to have the right amount of assets in it. And, it's designed so that individuals don't lose their government benefits. But, I think that's the least important reason for setting them up. Because who knows if government benefits are going to be here in the future. Can anybody tell me for sure that Social Security is going to be in effect in 10, 20, 30 years so that, they can rely upon SSI and Medi-Cal? We don't know. So setting up a special needs plan, it's even more important to design a plan that's going to work for the next 50 to 75 years and provide advocacy for your special needs child or your special needs individual for the next 50 to 75 years if you weren't able to take care of them yourself. Again, we already talked about, asset protection for your children. So you can design a family plan that protects the assets for your children for multiple generations, for your children and your grandchildren and your great-grandchildren. It can go on in California for 2 or 3 generations if you wanted to. If you have blended families, you have children from prior marriages. In that situation, you may want to have a customized plan that addresses those situations and provides what we call a Q-tip trust that can allow for the surviving spouse to be able to have whatever they need, but ensure that your half of the assets go to your family rather than her family, for example, or his family in that situation. So there's all kinds of planning that a family plan can take care of. We've also already talked a little bit about business succession planning. So, most businesses, 90% of them don't make it to the second and third generation. And startling statistics, over 30% of family businesses will survive into the family's second generation, and 12% make it to the third generation. Pretty scary, aren't they? All that blood, sweat, and tears that you put into your family business doesn't make it to the next generation. Why? Because you didn't address estate planning, because you didn't have a proper succession plan. You didn't plan for what we call the 5 Ds, which are planning for death, planning for disability, planning for divorce, planning for dementia, and planning for dissolution of the business. So if you're a business owner, you have to have a succession plan in place that addresses all these things. But again, people procrastinate, or they start a business and they're like, okay, I want to get to work. I want to make money. I don't want to think about these things. I want to figure out, what's my marketing plan and what kind of products am I going to sell and this and that. They're not thinking about what happens if I lose capacity, what happens if I pass away, what happens if my partner gets divorced, which is also a terrible situation because if you are in a partnership and your partner gets divorced, guess what? Now you own the business with that partner's spouse. So there's ways to address these things. So you're not in business with your partner's spouse. If that's something that you didn't want to happen, then plan to make sure that that doesn't happen. If you're a foreign national, if you have assets in another country, then there are some types of planning that you can do and things that you need to think about. So, there's all kinds of things that are involved in estate planning. We talked briefly about a few of them. Any one of these topics we can probably spend an hour on, as I mentioned before. So let's talk about how do you get in place a plan for yourself, which is why you came here today, obviously, is how can I get a plan in place for myself? Or if you are, a WFG agent, you have this information now so you can impress upon your clients that they need to put this proper protection in place. So we have different ways to accomplish this. There's a do-it-yourself platform through Legacy Shield. So for somebody who has really basic, simple needs, you can send them to Legacy Shield. They can get a $100 plan and just put in place a will, financial power of attorney, and an advanced healthcare directive, which again, as I mentioned, is a good first step. But for a lot of people, that's not going to address their needs. The system is automatically going to determine, based upon some of the information you put in there, whether you should have a trust. And it'll advise you saying, based upon what information you put in here, you should probably have a trust and not a will-based plan. And it's going to tell you to do that, in which case then you upgrade to a will-based, trust-based plan, and that is then total of $500. Not an additional $500, it's $400 additional if you've already paid for the will-based plan. So that allows you to do your own trust. So if you want to sit down, put all the information in, put together your own trust, you know exactly what you need to do, and you don't need the assistance of an attorney, and you don't really, you're still going to have the assistance of an attorney to be able to ask questions if you have, certain questions. You can also plug into our monthly training where you can get, plug into that to see how to use the system and get a lot of questions answered about what certain things mean. What's a specific gift, what's a residuary gift, and things like that, I think are things that are gone over in those things, so that you can get enough information to be able to design your own plan. We also have an option where you can have a law clerk put the information in for you, and I believe that is $1,000. And then if you have, property that you need to transfer, it's $100, I think, per asset, per real estate deed that you want to transfer into it. Or you can have a more customized plan that's going to allow you to, ensure that the plan is designed the way you want it to be designed. It addresses some of those more customized needs that you may have. Again, if you have certain situations, you're going to have a customized plan regardless. And the system is going to tell you, in these situations, you have to work with one of our attorneys. So, for example, if you have children with disabilities, you have a high net worth estate, those are some of the examples where it's going to say you have to work with an attorney. I believe if you have prior marriages, it may also suggest that too. So if it says that, then you're going to work with an attorney. But if you do have a situation where you know that you would like a more customized plan, you would like to leave a legacy for your children for multiple generations or provide asset protection for them, or you want to ensure that, there's a, so the Legacy Shield platform is going to ensure that we name guardians. And again, that is great. You've named guardians. But that can leave a few holes in the plan. And so in my office especially, we give our clients the option to opt into what we call a complete kids protection plan. So if your long-term guardian happens to be vacationing in France and your kids are home with a babysitter, when something happens, the police are eventually going to locate your kids. But they're not going to be willing to take the risk of leaving your kids with your babysitter or with a friend or a neighbor. What do? They call in Child Protective Services to figure out what to do. and Child Protective Services takes your kids into custody. Now, as a parent myself, I wouldn't want that to happen even for a minute. Knowing, the situation, parents, kids all by themselves frightened with a complete stranger. So we offer our clients the ability to have a kids protection plan where we not only name the long-term guardians, we name first responders. That's anybody who can get there in, 15, 20 minutes, counting on traffic. All these days, we don't have to worry too much about traffic. We also make sure that everybody has instructions knowing exactly what to do in case of an emergency. We have the parent carry around an emergency ID card that says I'm a parent with minor children and has the names and phone numbers that need to contact in case of an emergency. And we also have a healthcare power of attorney for the minor child so somebody can make medical decisions for them. So if that's something that's important to you, you're going to want to sit down with me and design a more customized plan. If you're comfortable with just naming long-term guardians, and that's what you're going to have in the Legacy Shield platform, and then you can have a do-it-yourself plan. So those are some of the examples of added value, additional things that you can consider when you're working with an attorney. Also making sure that all the assets are transferred, that everything is done in the right way, and that the plan, it's going to work when you need it to. Because so many people set up plans and they stick them on a shelf, they put them in a drawer, and they forget about them. And things change over time, and there's no real update of those plans. There's no real communication or relationship with the attorney. And so, those plans go stale. And a lot of times they don't work the way they were designed to because they aren't kept up to date. So that brings me to another thing. An estate plan isn't something that you do once and forget about it. It's a process. It's something that you should be looking at least every 3 years. I tell all my clients come back every 3 years. Sometimes in more sophisticated situations, you want to come back every year instead of every 3 years. And anytime there's a life-changing event, birth of a child, marriage, divorce, start a business, win the lottery, anything that changes your situation significantly, you're going to want to revisit that plan. So the do-it-yourself plan is one option. The customized plan is another. Now, you always have the option of just saying, I'd rather first start the conversation with a Legacy Shield attorney. Let that attorney tell me what the options are. Should I have a basic plan? Should I have a trust plan? Or should I have a more customized plan? And they can point you in the right direction as to what you should do in your situation and at least let you know what the options are. And so you get to make an educated decision. So you're welcome to start the conversation with myself or one of the Legacy Shield attorneys. One of the benefits of the Legacy Shield network is that we waive any consultation fee. So whereas I normally charge $450 an hour to sit down with a client, I'm waiving any consultation fee. So we'll sit down with you. We'll help you figure out your situation. There's no charge. And then, in addition, we significantly discount customized plans. So you're going to save, at a minimum of $1,000 to $2,000 off what would normally be charged by most attorneys for the same planning that we would put in place, depending upon your situation and depending upon the what type of planning you need to put in place. So these are the different options. This is the Legacy Shield number to reach them directly, where you can discuss with them. They'll address your situation. They'll point you to the attorney who will be able to address your situations. But also you can contact me directly. So here's my contact information. This is my first number is my office number. So if you just want to schedule a consultation, just call the office number and you can schedule it that way. Feel free, if you have a question about how the Legacy Shield platform works, if you're an agent and you have questions, call me on my cell phone you see the number 818-424-2789. That's my personal email address as well. So I want to thank you again for attending. I know there's probably some questions that may have come in by chat. we can take a look at those. We can answer them. If anybody has any questions, we can open up the lines and we can get your questions answered. So anybody have any questions? Looks like,
Hello? Hello?
yes, I'm here.
Yes, hi, I have a question. Yes, can you hear me?
I can.
Okay, so what do we need to meet with you? When we meet with you, what do we need if we want to do a living trust? Do we have to bring, what do we have to bring with us when we meet with you in the consultation?
Well, you don't necessarily have to bring anything. We'll send you a form to fill out, which if you get a chance to fill that out, it does help streamline that initial consultation process. You want to start being able to get together information on, your financial documents, your bank accounts, your IRAs, your 401ks, and things like that. If you have it handy, a copy of the deed to the real estate, although when we do the planning, we always pull up a property profile to make sure that, we're always looking at the most recently recorded deed and there's no issues with the chain of title with the property.
Oh, great. Thank you. Your information was very great. Thank you so much. I'll be making an appointment.
My pleasure. Thank you. Thank you.
Hi, Jerry. It's Camille.
Hi, Camille.
So my question is that if we have a client that already has had a trust put in place, but they want to take advantage of what Legacy Shield has for the future, is that something that they can take in part?
Well, if they want to keep their existing trust, they can still use the digital vaults. If they want to, what we typically do in that situation is we do what's called a restatement if they want to create a brand new trust. What we'll do is we'll restate the old trust. And what that means is that we'll keep the name the same. So if it's the 2000 trust, for example, it'll still be the 2000 trust. And that way, whatever's already titled in the trust doesn't have to be retitled. So it saves on work for us and for the client. And basically, it's like amending the trust in its entirety. So you get a brand new document, all now with all your current wishes, all brought up to date with current law and current information.
Meet with the lawyer.
Okay, the last question I have is, can you explain what capacity means?
Sure. Yeah.
So we signed up.
Capacity, well, capacity, there's different kinds of capacity. There's the capacity that, a mental professional would look at. And there's also the capacity of what we look at as far as in the legal field. So having legal capacity means that you have enough capacity to be able to execute documents. And there's different standards of capacity depending upon whether you're deciding to execute a will versus a trust. For a will, it's a much lower standard. For a will, all you have to do is understand the nature of your bounty, which means what assets you have, who are your heirs, and what do you want to leave to whom. So if you understand those three basic things, you have enough capacity to make a will. Capacity to contract is a little bit higher standard. It's basically having enough understanding at the time that you actually execute the documents to be able to understand the consequences of what you're executing. Does that make sense?
Great, thank you. Yes.
Sure.
Hello, Jerry.
Hi.
Hello, Jerry. Hi. When you mentioned the kind of things to put together for a person with special needs, suppose you have a child with special needs, what kind of assets should you be considering to put in a trust for them?
Well, again, this is a conversation that we could probably spend an hour explaining how special needs and special needs planning works. we should have, a one-on-one consultation. And yeah, we should sit down and have a one-on-one consultation, and I can show you the different options. But in a nutshell, you can have a revocable trust that creates a trust when you pass away, or you can have a special needs trust that exists now. A lot of times we do both, and getting into the reasons why is, we will have another presentation on that in the future as to the reasons why we do that. But you can put just about anything into a special needs trust, but be careful with tax-deferred assets because there's some special considerations with tax-deferred assets.
Thank you.
Jerry, question for you.
Yes.
So if a person has several real estate properties that are income properties, so some of us are investors, and we already have a trust already, do you recommend us to renew the trust and to add those income properties, or to avoid probate?
Oh, absolutely. Yeah. As I couldn't stress strongly enough, you want to make sure everything you own and everything you control is part of that trust. Because if you leave just one thing out of your trust, you're going to have a probate.
Okay, thank you.
And I may be slightly exaggerating. You can leave small things out of the trust. There's certain small exemptions in California, but the general rule, get everything in your trust.
Thank you.
You're welcome. Oh, and also, I would recommend, if it's, a little bit out of date or they want to make changes that, we do at the same time of putting the properties in the trust, that we do a restatement to bring it up to date.
Okay, thank you, sir.
You're welcome.
Jerry, my name is Elvia De La Riva, and I have a question for you. Is there a specific checklist that we can use kind of to help us, guide us through this?
I'm not sure what you mean by a checklist. Yeah.
Of the items, for example, that you should be including.
Well, the items that you should be including, are you talking about when you come to a consultation, or are you talking about as part of the estate plan?
As part of the estate plan.
Oh, okay. I think on the Legacy Shield network, it tells you what general items are included in a will plan versus a trust plan. But a will, will-based plan has a will, a financial power of attorney, an advanced healthcare directive, and a medical privacy waiver. A trust-based plan has a trust. It has all the things I just mentioned. It has a special kind of will, which we call a pour-over will. It'll have a few other things that go along with it. Assignments of personal property, potentially assignments of business assets, deeds transferring title to the property. In some cases, if you're married, a community property agreement. So there's a lot of other documents that go into a complete revocable trust plan, estate plan.
Okay. Thank you for that. And then the other question, I don't know if I missed, did you indicate what the cost would be for a customized plan?
I did not. I mean, for customized plans, typically they start at around $2,000 and go up from there depending upon the complexity of the plan.
Okay. Okay. Thank you for that.
I see somebody's asking, can you put foreign properties in a trust? And the answer is, it depends. If you have foreign real estate, generally real estate is generally controlled by the situs of where it's located. So typically, we're not going to put foreign real estate directly into a trust, a U.S. trust. A lot of times what we do is probably consider putting it into a offshore corporation or LLC, and then have the trust own the offshore corporation or LLC. It really depends on the country, and we'd have to look at it on a case-by-case basis to see, if there's any particular treaties in place or things like that that allow a U.S. trust to own foreign real estate?
Jerry, I think it's safe to say it looks like there's probably going to be some people asking more questions. And I think that given the scope of it and the specificity for some, one of the things I would recommend is reaching out to him directly because you are coming as part of the network. That's part of what you would get is that free 1-hour consultation. So one of the things I would recommend is give him a call, let him know that way he knows you were on this webinar, and then which associate invited you as well, just because that'll help him tie it to the discounted plan that he talked about here. And then I think that and you tell me, I mean, because I just think that there's, as having gone through this myself, I know that when one topic comes up, like several other layers. And I remember one of the questions that was brought up was, we have at that time I had 2 kids, and the attorney asked me, well, what if your son passed away and didn't have children? Would you be okay with his spouse taking all the assets that you have left for your son? And I kind of had to step back and go, I don't know, right? And so I think that's one of the things I would let everybody know. Depending on the scope of your situation, will depend on what you really need. Some probably are going to be very basic and others more complex. I would encourage you, because it is free, it is something, and something I'll tell you is, having been in the industry, Jerry, I appreciate your sincerity, just your genuineness and wanting to answer questions for people. And I know that there's going to be a tremendous amount of value there. So I would definitely encourage that to probably go ahead and reach out. And if you want to make any other closing or final statements, Jerry, within this.
No, thank you. Thank you again for having me. Thank everybody for attending. I think we had about 75 people on today, and
we actually filled up our lines. We were at 100, and so there was people that couldn't get in.
Wow.
So yeah, I actually was getting a few messages. It was just some people couldn't get in. We got to 100, and so we'll probably talk about having another one, hopefully in the near future, because it definitely did fill to capacity. So we weren't able to accommodate for everybody who had the interest in participating. But thank you so much, Jerry, for being
I know
client this evening.
Oh, you're very welcome.